Hello, my name is Barbara Reiser. I've been teaching the family guardianship class for at least the last 20 years. My background is in social work and public administration. I am a professional guardian. I've worked with elderly services and the ARC South Florida and United Cerebral Palsy, so I'm well acquainted with the elderly population and the developmentally disabled population. Your family members are lucky to have someone like you who came forward to take on the responsibility of being a guardian. When an individual is adjudicated incapacitated and there is no one to come forward, the court will appoint someone like me or my agency to be the guardian. In 2002, when the legislators voted to close the institutions in Florida, there were many residents abandoned by their families. They had nowhere to go and no one to care for them. Coincidentally, at that time, the statute changed, and it allowed for more than one public guardian in each jurisdiction. I jumped through the hoops to become the second public guardian in Miami-Dade County. This enabled my agency to participate in the deinstitutionalization of Landmark and assure that those individuals were appropriately placed with all benefits. Here we are, 20 years later. Most of our wards are still with us and thriving. And our newest project now is serving those youth who are aging out of foster care. Okay, enough about me and my agency. Congratulations to you on coming forward to be a guardian. That is awesome. That's a huge responsibility and a true labor of love. Not only are you a family member, a loving family member, you are now legally responsible. You're expected to be up to date with all the statutes, all the services, and any benefits that your ward may be eligible for. Hopefully, you've taken the 8-hour class, and the Florida State Guardianship Association will continue to have updates and seminars so we can keep you abreast of everything that you may need to be the guardian, the best guardian that your family member ever had. When I teach the class, the first thing that I ask is if everyone has their certified letters of guardianship. These are your marching orders. These are the blueprint of your responsibilities, the rights that have been delegated to you. These certified letters will open the doors at the bank, the doctor's office, and help you to apply for benefits. Once you actually have your certified letters in hand, then you can go through the process to apply for pensions, Social Security, to become representative payee, and set up your restricted and unrestricted account. Just a disclaimer here, I'm not teaching the class, and I'm not an attorney. I'm sort of just highlighting and going over what you already should know and emphasizing some of the information that I think falls between the cracks in the classes. Florida State Guardianship Association requested for me to address some of the frequently asked questions by family guardians. The number one question that everybody asks for clarification is always about traveling. If the right to travel is taken away, do we need to petition the court for a court order to travel beyond neighboring jurisdictions? The answer is yes. This always generates lively discussion, sometimes anger and regret. What have I gotten myself into? Why did I need to do this? My advice: speak with your attorney. Your attorney knows the judge and will be able to interpret the statute. If required, my advice to you to discuss with your attorney is to ask for a standing court order. Let's say you live in Tallahassee or Miami and you are the guardian of a ward who participates in the Special Olympics, and you know when those Special Olympics are, or every year you go to visit Aunt B in North Carolina for Thanksgiving. Think about it, speak with your ward, try to get a standing court order so you're not in and out of court all the time and having to spend extra money on attorney's fees. The second most asked question is, if I'm the parent, why do I have to become the guardian? Good question. There's a lot of emotion around this topic. Obviously, someone advised you to become legal guardian for your adult child. In the state of Florida, once someone turns 18, they are considered to be a legally competent adult. The only way for you to continue to make decisions is to have your child adjudicated, incapacitated, and have their rights delegated to someone else, hopefully you. The court found your child to be incapacitated. There was an adjudication, and the rights were delegated to you to act upon. Guardianship is based in Florida statute 744. There is nothing intuitive about guardianship. That's why you take the 8-hour class, you attend seminars like this, and you have a lawyer to help you to navigate through the system and to keep you out of trouble with the court. The next most asked question is, okay, now that I'm the guardian, how do I make decisions for another person? You are now a surrogate decision maker. There are standards that we use in guardianship. The standards that we use when working with somebody who once had capacity, it's called substituted judgment. And for someone who never had capacity, they have a developmental disability or a brain damage, we use the best interest standard. So, for example, you are the guardian of your mother. She once had capacity. The absolute best case scenario would be if your mother, when she still had capacity, created advance directives and named a healthcare surrogate, if she created a living will, and power of attorney documents. There's your roadmap. Guardianship is not about what you think that you should do for your mother. It's about creating the least restrictive, most normalized setting, and by honoring the wishes of someone who once had capacity. In the absence of clear advance directives, try to think about discussions you may have had with your mom. Did you ever discuss end-of-life issues? Were you in the hospital with her visiting Uncle Joe, and he was full of tubes and in ICU? And did your mom ever say, oh my God, I never want this to happen to me? Or, yeah, I'd like to be kept alive at all costs. What would be her preference for funeral arrangements? Did she believe in cremation? The legislative intent here is the least restrictive, most normal decision. Use this across the board in healthcare, housing, and in all aspects of your ward's life. I'm going to stop now just to emphasize the importance of advance directives. I'd like to use this lecture as a wake-up call to all of you to minimally take away the importance of advance directives. This way, if something happens to you, you have your express wishes documented as detailed as you wish them to be, even to the point of naming a guardian. Start the conversation now over dinner so as many people as possible know what your wishes are while you still have capacity. You never know what's going to happen. Hopefully, you can avoid guardianship for yourself. Okay, now back to your responsibilities as a guardian. How do you make decisions for someone who never had capacity? Well, you use the best interest standard. You make a decision as a parent would based on what is in that person's best interest. Overall, guardianship is a balancing act. Obviously, all decisions are based on a balance of finances. Can we afford it? Is there insurance there? Best interest or substituted judgment, safety, and input from experts or professionals. You are not alone, and you are not making decisions in a vacuum. In some cases, you can ask the court for direction. Another topic that's frequently brought up is, why do I need to have an attorney? It's bad enough that I had to go to court and become the guardian of my child, and now to add insult to injury, I have to pay someone? Well, at present, Florida statute states that every guardian must be represented by counsel. They represent us as guardians to the court. I know that there are some cases where family members were able to speak with the judge's assistant or speak with their attorney, and the judges allow them to present in court pro se, which means by themselves without a lawyer. By all means, if you can work something out with the court or with your attorney, I would say go for it. It'll save you money, but at present, what I know of, you still will need an attorney to sign off on the documentation and to e-file the reports. Hopefully you have a really good relationship with your attorney and they're knowledgeable and you can speak with them freely and discuss this subject. Why do I need to set up a restricted depository? Well, the short answer is because it's not your money. The main restriction of the depository is that no funds can be removed from the account without a court order. The funds can be accessed as follows. The guardian prepares a monthly budget of needs of the ward and petitions the court for a standing order directing the bank to withdraw that sum of money on a monthly basis, either to an unrestricted account or to a cash account. Should an unexpected cost arise, the attorney needs to petition the court for payment. In Florida statutes, there is a list of rights that are always retained. Even though someone is adjudicated incapacitated, which is the most restrictive alternative, they always retain the following rights. And I'm going to read this because I think it's really important. We're dealing with a very, very, very restrictive alternative. And I just want everybody to be mindful of the fact that under the Constitution of the state of Florida, these are the rights that are always retained. Number one, an annual review of the guardianship report and plan. Number two, a continuing review of the need for restriction of his or her rights, restoration to capacity as soon as possible, humane, dignified, and respectful treatment, assignment of a qualified guardian. That's why you're listening to this. That's why you take the 8-hour class. Freedom to be as independent as possible, a proper education, proper and prudent financial management, access to services and rehabilitation necessary to maximize the quality of life, equal rights regardless of his or her incapacity, access to the courts, representation by counsel, visitation and communication with others. Even though Aunt Mary is a pain and she upsets your ward so much, if your ward expresses that she would like to have a relationship with Aunt Mary and she did not retain the right to make that decision, really you need to honor your ward's right and allow her to have that visitation and communication. Adequate notice of all proceedings relating to the determination of capacity and privacy. Your ward actually has the right to privacy and it really must be honored. I noticed that many family members are not knowledgeable about benefits. So that goes right into number 5, which is the rights that are always retained, that you should have a qualified guardian. Some of the things that I would like to briefly touch on is that you do have a responsibility to make sure that your ward receives all benefits and services that they're entitled to. It's your responsibility to write letters for all pensions and any Social Security benefits they may be entitled to. And I'd like to bring to your attention a few programs that may help you. We always talk about the Medicaid waiver program for the elderly and the Medicaid waiver program for developmentally disabled individuals. So When I was doing my research, I was shocked to find out that as of March 1st, 2014, Florida discontinued all Medicaid health and community-based services waivers relevant to the elderly for long-term care. What they did was they just reconfigured it, and it's now called the Statewide Medicaid Managed Care Program, or it's known as the Nursing Home Diversion. Medicaid-eligible seniors who require long-term care can receive assistance at home, the community, or in assisted living facilities. Who's eligible for this? First of all, they have to be a legal resident of the state of Florida. They have to be a minimum of 65 years old or designated disabled by Social Security if they're younger. They need to have a nursing home level of care, and we'll go into that definition in a few minutes, and meet the financial requirements of Florida Medicaid. What is a nursing home facility level of care? What that actually means is that they need assistance in 2 or more activities of daily living, or they need supervision due to severe memory impairments. What's the application process? So it's through your local area agency on aging. You can always call the elder helpline in your county to get assistance. Some counties have waiting lists, others have enough funding and will be able to meet the needs immediately. It goes county by county. Some of the services that may be offered would be companion service, daycare, assisted living, attendant care, meals, equipment, OTPT, occupational therapy, physical therapy, speech therapy, med management, and some services in nursing homes. So it would be worth it to call your area agency and see what services are available in your county that you can help your ward with. The other Medicaid waiver program is the Developmental Disabilities Waiver. It's now called the Developmental Disabilities Individual Budgeting Waiver, or the iBudget Waiver. And the purpose of it is to provide home and community services, supports and services to eligible persons that have developmental disabilities who live at home or in a home-like setting. They use a budget, and for higher functioning individuals, it's an opportunity for self-determination. It's designed to promote and maintain the health of the eligible individuals with developmental disabilities and to provide medically necessary supports and services to delay or prevent institutionalization. To qualify, you must meet the eligibility requirements in accordance with Chapter 393 Florida statute. That's the developmental disability statute. You have to meet the level of care criteria for placement, and you have to be eligible for Florida Medicaid and diagnosed with one or more of the following. You have to have an IQ below 59, or if your IQ is above that, you need to have a secondary condition such as Down syndrome, CP, Prader-Willi, spina bifida, or you could be eligible under the Agency for Persons with Disabilities with a diagnosis of autism, CP, Down syndrome, Prader-Willi, or spina bifida. The services include adult daycare, may include dental services, behavior services, companion services, medical supplies, a dietitian, all the therapies, personal supports, residential habilitation, respite care, home care, support coordination, very important, supported employment, supported living, and transportation services. I hope these highlights from my classes have been helpful for you. Please follow up on these suggestions in your community so you can have all the help that is offered for your ward. Best of luck, and remember, Florida State Guardianship Association is here to help family guardians also. Thank you.